Welcome, everyone, to our first CSBARS meeting of the new year, 2025. At this time, if we could ask staff just to do our roll call, please.
Jason Amesqua,
Here.
Dr. James Bolton, Jay Friedberg,
Present.
William Hunt,
Present.
Paul Kramer,
Present.
Kevin Marshall,
Present.
Philomena Yuroshek. We have a quorum.
Thank you. Next, we will turn to public comment. Members of the public can make written public comment submitted to csbars@calbar.ca.gov or our CalBar email box. Written public comments were received and distributed to CSBARS members already. Verbal comments made up to 3 minutes will be taken now, first recognizing any individuals who signed up in advance using the link on the agenda. None have signed up prior to make such a motion, or by raising hands using the raise hand function on a computer or star or asterisk 9 on a phone. Staff will share a timer on the screen during any such comments if they are made. Do we have anyone wishing to give public comment at this time?
We do.
We do. I would like to recognize Todd Hill for a 3-minute public comment, please.
Thank you. Good afternoon, Chair and member of the committee. My name is Todd Hill, and I appreciate the opportunity to speak today. I'm here to address systemic gaps in oversight, procedural inconsistencies, and transparency failures affecting law students, particularly those attending unaccredited and state bar accredited institutions. Agenda item 3.3, report on the February 2025 bar exam, presents an opportunity to acknowledge ongoing misalignment between unaccredited law schools and the state bar's eligibility certification process. Students who meet statutory requirements should not face institutional roadblocks due to conflicting policies between law schools and the state bar. I have personally experienced delays and procedural misalignment in this process, where school declined to certify my eligibility based on internal or lack of clear policies, despite the state bar's prior determinations. These issues must be addressed to prevent unnecessary barriers to students' access to the profession. Additionally, as the committee works on agenda item 3.2, revisions to unaccredited law school rules and guidelines, I urge you to incorporate clear records and retention policies under Rule 1.15. Law schools operating under the state bar's oversight must be held accountable for maintaining and disclosing records appropriately, particularly during transitions or closures. Institutions cannot be allowed to arbitrarily redact or withhold records that impact students, alumni, and regulatory oversight. The misalignment between unaccredited law schools, state bar accredited institutions, and the state bar's eligibility certification process creates unnecessary barriers for students transferring between these institutions. Under Rule 4.26b1 of the California Rules of Admission, law students must complete 4 years of studies to sit for the bar exam. However, students transferring from an unaccredited law school, such as People's College of Law, to a state bar accredited institution, such as Purdue Global Law School, often encounter conflicting policies on credit transfers and certification requirements. In my case, despite meeting the state bar's eligibility criteria based on statutory requirements, procedural delays and inconsistencies between institutions have led to unnecessary barriers in certification. This gap in regulation must be addressed to ensure that students are not penalized due to administrative misalignment between legal education providers. I urge the committee to clarify and align transfer and certification policies between unaccredited and accredited institutions to ensure students can complete their education and qualify for the bar without procedural roadblocks. Notably, students that are required to transfer due to schools' voluntary or involuntary closure often face the prospect of requiring an additional year or 2 of studies to earn their degrees, based on the accepting institutions' limits on transfer unit acceptance or residency requirements. This clearly increases the cost and burden on the student, where the reasons for school closure are generally far beyond the impacted individual's control. The committee should ensure that unaccredited and accredited schools have clear, enforceable policies that align with state bar determinations. A review of certification guidelines, unit transfer policies, and school closure protocols should be a priority. Thank you for your time and consideration.
Do we have anyone else that would like to give additional public comment at this time?
Thank you. I don't see any other hands raised at this time.
Thank you for the public comment received currently from this meeting, as well as from our prior written public comments, again, distributed to our committee before this meeting. I'll move into our chair report. First, I just wanted to send a personal thank you to the bar. Often we point out what the bar does wrong, and I think it's always good to point out what is being done well, and specifically, especially the members of the staff that are on right now. Cody Hunani and Natalie Leonard, Teresa Solonsky, they all reached out. Again, UWLA is in LA, where all the fires have been, surrounding our campuses. We've had many faculty, students lose their houses, and they were proactively reaching out to us and seeing what they can help with by email, by phone. And again, I think that's something that we need to encourage, reaching out to each other, helping each other, helping the students through this process. Especially, I'd like to highlight, in case it's helpful to anyone else, through the Lawyer Assistance Program, LAP, they were giving an offer of 2 hours of counseling. So 2 counseling sessions of 1 hour each to anyone who, my understanding, was an attorney, is an attorney, or currently in the process of going to law school to become an attorney as they go through this. And I think that is something very helpful. A lot of people aren't taking account of their mental health as they go through this process when many have lost everything. As an example, I've talked with faculty who lost their books, but they're still teaching. So we had to make sure to get their books. So I imagine their mental attitude as well needs mental health treatment. So I'd encourage everyone to participate that if they can. Similarly, if you haven't been following along, there's an extensions to MCLE. Although our MCLE notice is normally due this Friday, there was an extension of that. Again, I think all of these things are great avenues of showing the state bar is not just there to regulate us, but also to work with us in that process. Separate from that, I was asked to touch on that the first year law students exam pass-fail list for October has already been distributed, and to please remind everyone to keep your emails updated for the state bar. And again, they will only email it to the dean, so make sure your dean's email is updated as we go through. And we have our upcoming CBE meeting, which will focus in large part again on our upcoming changes to the bar, as well as to this upcoming February bar. So I'd encourage everyone to participate this Friday, if possible, or at least listen in and give public comment if there's any areas of special interest to you. With that, I'll turn over to our director's report now.
Great. Thank you, Dean Frickberg. I wanted to just highlight, I think there's several topics on today's discussion that are very timely. Dean Frickberg, you just mentioned some of our response to the wildfires. And of course, we have some updates regarding the bar examination in February of 2025. For our audience members, I wanted to take an opportunity to underscore one of our channels of communications with the public that maybe is not addressed often, and that's our social media channels. So I wanted to give our audience here, as well as, of course, our law school stakeholders, this reminder that we are posting regularly on our Facebook account, and our State Bar Facebook account is facebook.com/statebarofca. We're also providing timely updates on X, or formerly Twitter, with the handle StateBarCA. And I get a lot of our State Bar news on LinkedIn as well, where we are providing updates under the handle State Bar of California. And I'm just looking at our news feed, all of what I've just mentioned, updates about today's committee meeting, updates about wildfire relief, and information about the bar exam is all being shared. So this is a great place, not just for admissions related information, but information across the state bar. And we have not provided this reminder in some time, so this is a great chance to remind our stakeholders and the public that these resources are shared online on social media. Thank you for that.
And with that, we'll turn over to our staff report now.
Thank you. It's actually back with Cody again.
Oh, is it?
Yeah.
Yes, so I wanted to provide an update regarding the proposed revisions to the rules and guidelines for unaccredited law schools. As a reminder, at the December 2024 committee meeting, the committee considered the feedback received by CSBARS members at 2 meetings held in October and November. I wanted to take an opportunity just to thank the members here for those discussions. They were robust. We received a lot of candid feedback And I really enjoyed and appreciated the opportunity to hear from you all, and the fact that you all were able to own certain issue areas and bring some really valuable feedback to both us and the committee. Since then, the Committee of Bar Examiners, Educational Standards Chairs, and our staff have been working on not only the proposed revisions to the rules that were discussed, but the necessary revisions to the guidelines to comport with these new proposed rules. Some of the goals of our effort to review and address the guidelines center around, I think, some important goals. So we have, I think, just generally making the language more clear and comprehensible. We have another goal of moving some of our key requirements out from the guidelines into the rules to improve transparency. And we've, I think, really leaned into a data-driven approach to assessing law school performance. And we discussed some of the opportunities with the members of CSBARS in October and November around different data points, including our retention figures. So we've done a lot to review the guidelines. This was slated to be discussed at the January 31st committee meeting. It's been withdrawn, and there's a focus on the bar exam. So we anticipate that the Committee of Bar Examiners will discuss these revisions at the March 14th committee meeting. So that's really the next big update to share. And then I have a second update, so I'll just move us along in the agenda. I wanted to provide our members an update regarding the February bar examination. So first, I think we are really excited to report that we're expecting a relatively large February 2025 bar examination. We currently have over 5,400 approved or pending applications for the exam. And last year we had just 4,300 sit for the exam. So these numbers are pending, and there'll be some fluctuation, but we can certainly expect a good turnout. I wanted to reflect on the last week of deadlines and updates. Last week, we hosted a Q&A session for members of the public to speak to us about the February bar examination. We had over 100,000 people, over 1,000 people attend. It was quite a showing. At the end of last week, we sent a communication to applicants that provided responses to some of the most common questions that we received. We're also preparing some additional resources based on the feedback that we received in that meeting, and we'll continue to update applicants. But it's been really, I think, effective to get some real-time feedback and try to provide clear responses to that feedback as soon as possible. Last week also marked the deadline for applicants to complete the mandatory mock exam for the February exam. And as a reminder, the reason the mock exam is required is because it's our opportunity to ensure that applicants are familiar with the software and that applicants can address computer equipment issues, before exam day. I'm happy to report that the vast majority of test takers successfully scheduled and completed their mock exam without issue. And so that, I think, allows us to turn ahead to our next set of upcoming deadlines that are very important. So tomorrow, January 30th, that'll mark the opening of the exam session scheduling window. So applicants who have completed all of their requirements to date now need to schedule their session for the February exam. Applicants are going to receive a communication tomorrow with instructions on how to schedule, and they will have between tomorrow and February 14th to complete that scheduling. February 3rd also marks the final deadline to file a testing accommodations appeal, and emergency testing accommodation petitions must be filed before February 14th. And lastly, I just want to underscore some of the resources that I've already touched on, but let's shed some light on them. Each week, we are sending to applicants a countdown email, as we have done in the past, and we are forwarding that countdown email to our law school deans and other administrators. This is the most effective resource as far as a communication resource to reach applicants. We have each week up to 80% of applicants reading this content. So it's an incredibly valuable opportunity for us to provide information. We are also continuously updating the exam FAQs document, which is, again, a resource that we provide each exam. The most recent update was made this past Friday, January 24th. Yesterday, we also launched the bulletin. Each exam applicants would receive what in the past was called the admissions bulletin for the exam. This year, because of kind of the change of procedures, it is called the Policies and Prohibited Items Bulletin, which provides specific information about the exam day policies. And we all are also producing some additional resources, again, based on the feedback that we received from our applicants in law schools. And there'll be more to share about some additional resources in the coming weeks.
Thank
Great.
you.
Thank you. Thank you.
One quick question, if I could,
Yeah.
just out of curiosity, and I'm always a student of history. I think we saw a similar increase during COVID with the online administration of the last California bar. Are we tracking on the bar side to see, are these examinees out of California that is causing the increase, or are they all within California? I don't know if we've researched that data already.
Dean Fricker, you're right on the pulse. We are looking at that. I don't have numbers to share today. One of the things we'll be sharing with the Committee of Bar Examiners tomorrow, on Friday, is a dashboard that we are preparing first for the committee's use and then in the future for public access, where we are going to be sharing our bar exam cases submitted and a breakdown of those demographics, regarding their background as an applicant type, whether they're a U.S. student, foreign attorney. So we're going to have more access to insights about that, and we're also just doing some more in detail analysis that might be ready to share. That specific statistic might be ready to share on Friday. If not, I'm sure we'll use it to describe this administration and future resources. But the short answer is yes, we are wanting to understand. We think it may be a shift in the population of the test takers. Or it could also be because of the new modality and access to the exam. We want to make sense of that.
Absolutely. Thank you. Our next area is just the committee report. I was asked to touch on that. And we have also our member, Paul Kramer, and CSBARS is also a member within the CB. So if there's any additions, corrections, deletions, I definitely always appreciate those as we go through. Many of the things that I was going to touch on already were discussed by Mr. Unanian. Again, those were a recap of what was presented to the CBE in December 6th, their last meeting, which in turn was really a recap of our CSBARS meetings from October 8th and November 1st. So I don't think anyone within our group would have a surprise, at least that shouldn't occur. One of the big areas was the modality, and the committee actually spent about an hour. It was about an hour in this area, so I think there's a good discussion and presentation as we go through that. If anyone is interested, if you haven't already looked at it, I think staff did an excellent job in attachment 4.2 from that meeting, which is a good synthesis of everything that we were talking about within CSBARS. There was discussion of the modality, asynchronous, synchronous. The committee went further into discussing, where should that line be? Is it 80%, within one, and then you can have a 20% variance as you go through. The conversation of the major change, the move of campus of less than 5 miles, discussion of time response from the committee back to the schools versus just the schools. We discussed the transparency of the term unaccredited and is that the best terminology to use? Also, the conversation on student complaint documentation, what does that entail? Again, one of my concerns being, do we have to document an oral complaint about a temperature in a room? How encompassing is that student complaint definition as we go through, especially with having to preserve those records long term. Very good conversation at length on NPR and the potential of the first year NPR correlation to that. I thought the committee very well went into detail. There's that 4-year lag anytime you're looking at a registered unaccredited school. So if their NPR dips, if you change all of your teaching modalities, improve everything, you really won't see a substantial improvement until 4 years later. And is there some mechanism that can be built into that system? And a discussion of attrition numbers. Should there be a baseline attrition number? And should that be a requirement or just a posting? And finally, a good conversation on the idea of a standardized test like the LSAT Again, it's one of the areas I always disagree. And I think that Bolus's prior reports were based on ABA LSAT analysis, which is not, I would argue, would not correlate to CalBARS or the registered unaccredited schools as they go through. So that's just a short synthesis of what was discussed on behalf of the CSBARS at the CBE meeting last December. Our next area is just our minutes. So our minutes have already been disseminated to all committee members. And so at this time, I would ask if anyone has any points within the minutes from November 1st, 2024 of the CSBARS that they would like to have potentially changed or modified, or do we have a motion to adopt as is?
I'll motion to adopt.
Do we have a second?
I'll second that.
Second. And if I could ask staff just to put that to a roll call vote for us, please.
Jason Amescla,
Yes.
James Bolton, William Hunt,
Yes.
Paul Kramer,
Yes.
Kevin Marshall,
Yes.
Philomena Yaroshek, and Chair Jay Frickberg.
Yes, as well.
All right, with 5 yeses and 0 nos, the motion carries, excuse me.
Thank you. And that brings us to our business. I think that's a new record for CSBARS. We're 22 minutes in and we've made it to the functional part of our meeting. So thank you, everyone. With that, our first agenda item, 7.1, a discussion of proposed guidance on use of artificial intelligence in law schools. And I will turn that over to Natalie Leonard and Cody Hunanian.
Thank you. So before we bring up the presentation, just to put a frame around this, we know this is something that all of the schools have been thinking about right away. Just to refresh everyone, the Board of Trustees asked the Committee of Bar Examiners to look at emerging AI trends, technology, and use, and to understand if there should be regulatory requirements or regulatory support for law schools in the area of AI. So recently there was a second discussion at the Committee of Bar Examiners talking about general direction. I'll walk you through the steps that they took to get there, but ultimately they determined that the space is changing so quickly and the current rules are flexible enough that they are currently sufficient and that some practical guidance may be appropriate. And if anyone saw the news this week, you will see that in fact the space does continue to evolve markedly and did so even within a 24-hour period. So let's go ahead and bring up the slides just to bring you up to date with what was shared with the committee. And as we're looking at this, we'll ask for at least one, maybe a couple of contacts from CSBARS to inform staff as we prepare a presentation of possible guidance to bring back to the committee so you can help us to prepare that CSBARS discussion. Thank you.
Sorry, Natalie, just give me a moment to get this up.
Okay.
Teresa, would you like me to share the presentation? I have it in front of me as well.
Oh, do you? Okay, I think I might be able to pull it up. Thank you.
Okay. I know you've had some cursor issue. Great.
Thanks. Okay, so this is just to catch you up with what we shared with the committee. We added some background information at the front, primarily because the last time that the committee discussed AI, some members who are currently on the committee were not there. I think it'll be familiar to most. I'll just run through it quickly so that we're all on the same page as to background. Let's go to the next slide. Literally background. Let's go to the next slide. Okay, so the charge that is before the Committee of Bar Examiners is to look at whether there should be requirements for California schools regarding courses related to the competent use of AI and regulations or rules related to the bar exam or generative AI. So I'll talk as to the first bullet point and Cody will speak about the second. Okay, let's go to the next slide. So I think many of you know that there are largely two types of artificial intelligence that you're hearing a lot about and you're seeing in much more widespread use lately. Generative AI, so those are the large language models like ChatGPT, where you're entering a prompt and it's actually creating something new, or machine learning, which uses sample data to recognize patterns, often associated with neural nets, making predictions, judgments, or decisions based on what it sees in these complex neural nets. And you're seeing it used in many aspects of everyday life: product recommendations, spam filtering, predictive text. And I know that many of you are using it in your legal research classes, and that several of the schools here and in our larger audience even already have courses focused on AI. We're aware of at least one legal graduate program focused on artificial intelligence. Next slide. There are many actors that are looking into responsible use of artificial intelligence. There is a White House blueprint, an EU AI Act, a California executive order, and there are other bills being considered at various states of status in the California legislature as well. And in addition, the ABA has a task force on artificial intelligence. Next slide. So we started by looking at the attorney space, and so our COPRAC group, which looks at the ethics rules and rules of professional conduct, were the first to begin to study this subject because they began to see potential and actual uses of artificial intelligence in the practice of law. And as a result, they created a non-binding but guiding principle series of guiding principles that attorneys are asked to use at this time. This came about after COPRAC consulted a panel of experts who were active in the space, both academics and practitioners, and they determined that it is most related to Rule of Professional Conduct 1.1. I think we've gone over this type of slide before, but this is the process that they went through to recommend some practical guidance to the Board of Trustees, which the Board of Trustees did endorse and adopt. Next slide. So let's go to the next slide here, moving to what the committee considered. Here we talked about why does AI matter, AI guidance matter in education. First of all, making sure that students understand the risks and also potentially the opportunities in using AI tools, being ready to serve clients in the future, understanding that AI is already in practice in the practice of law, and thinking about how AI may affect very foundational parts of legal practice, such as attorney-client privilege, unauthorized practice of law, just overall compliance, and the potential for bias, depending on how the model is trained. Next slide. You may be most interested, for the various groups thinking about it, in the ABA task force of regarding law and artificial intelligence, because it's the closest to what we do day to day. So far, they've released some key statistics, which I've included here. Right now, 55% of the ABA-approved law schools that responded to their survey said that they offer classes dedicated to AI. 83% said they provide optional curricular opportunities. So we saw very, very widespread, quick adoption of this into ABA-approved programs. But we understand that there is a difference in resources and missions of the ABA schools versus CALS. Next slide. We reminded the committee of the various steps that you've all participated in. Here at the State Bar, we started engaging with you back in 2023 about AI in the Law School Assembly, where we brought practitioners from a number of areas, including one professor who created an AI student to attend his class, and at the end of the semester discussed how the student performed. And you might recall that the student was able to grasp basic concepts, but had more trouble with the nuanced concepts that are required of new attorneys. This was actually a computer science class, though. We also discussed AI with the Law School Council and the CSBARS as well, and brought it back to the committee back in December to get some directional guidance. We proposed 3 choices or considered a possible 4th from them. Let's go to that slide. And we asked them to try to bind their guidance around accreditation principles of consumer protection and transparency, student success, diversity, equity, and inclusion, and preparation for licensure and professionalism. Next slide. We talked about the role of the state bar, and this is specifically the guidance for the accredited rules, but we're imagining that the committee is open to a general guidance document that would apply similarly to both accredited and unaccredited, and we wonder what you think about that, and we'll open up the discussion soon. Next slide. We think that it's primarily the competency training and guidelines in the unaccredited schools that might already be touching on this. So in both sets of rules, you've got requirements to teach students practical skills and to make sure that they can do competent research and competent practice. And we think that at this point, potentially AI guidance falls within those rules. So we don't think that further change is required at this time, but we're interested in your thoughts on that. Next slide. So these are the options that the CBE discussed. Take no action as premature, consider providing a guidance document, update guidelines and rules, or another CBE preference that had not been yet discussed. And the committee selected number 2, interested in creating a guidance document for law schools. Their thinking was they wanted to recognize the existence, provide support and information on a safe harbor to schools, but also to take an introductory stance and be aware of this being a space that is changing very quickly. Let's go to the next slide and then open up the discussion. So given this posture, let's take the slides down. Or actually, maybe let's leave this up for a moment while we ask for a volunteer.
I guess I'll volunteer.
Okay, we could probably take another as well. The purpose of volunteering would be to be a contact for staff as we prepare a more specific discussion about what guidance could look like, probably having some relation to the attorney guidance that was provided to the Board of Trustees earlier in the year. We have 1 volunteer, and as the discussion proceeds, if there is another, you can let us know now or via email after the meeting. Okay, next slide. Let's take the slides down and we'll open up the discussion.
Natalie, I'd be happy to volunteer as well.
Thanks, Dean Marshall. Okay, so thinking about what we see ABA schools doing, the direction that we see the committee taking, how do you feel about the choice of a potential practical guidance document? Does this feel appropriate to advise you of what you need to be doing and also provide a safe harbor to make sure that you are doing all that you're doing at this time? And has much changed since we discussed this in the summer? I know that's not much time ago, but the space is really changing rapidly. When we last talked, we had 2 CALS programs that had AI courses, and nearly every CALS had incorporated AI into their legal research classes, and unaccredited schools were thinking about doing that. As we sit here and we take a little informal poll, I'd love to hear an update about what you've been doing at your school. And maybe we could start with Dean Frickberg, because I know that there's been quite a focus at UWLA.
Well, not much has changed for UWLA. Again, we started with first creating an institutional AI policy. That way to put faculty, put students on notice what would be acceptable, what would not be acceptable in the use of AI as they go through the school or they're teaching a course. Second, then we started an elective course on the modern law and the use of AI. And My personal belief is I think that AI will benefit the CalBAR schools and the non-accrediteds more than the ABAs. And that I see AI being an accelerant. Again, it won't give you the answer, but it'll help accelerate the process, similar to having paralegals and clerks draft out documents. And I think we're going to see a bias and a benefit towards AI usage in solo practitioners as well as in-house counsel. And we might see some corporations will not rely so much on larger firms when some of the work can be done by AI and someone that speaks their own internal language as an in-house counsel. Separate from that, of course, we've started integrating it into our more practicum-based courses, the legal research, the pre-trial, and the trial ad. So we're definitely trying to cross-pollinate as much as possible with it, because I don't think we have a choice. It is here. It is growing. It's getting less expensive, as we're seeing with the new DeepSeek version of generative AI.
Are there any other deans that would like to talk about what they're doing at their school? I see Dean Hunt.
I know that we have incorporated it into our legal research and writing course that will be running in May, or starting in May. And then we're also in, I don't know if the exploratory stage is what you would call it, but in the process of creating a course that focuses on what's appropriate within the practice of law and within law school as far as using AI to generate papers and what your responsibility is with that paper. That it's not just, well, AI produced it and turn it in. There has to be more to it on your side than that. So we're twofold: how to use it as part of your legal research and document production work as an attorney and as a law student, and just moving from there.
Thanks, Dean Hunt. And it might be a good time to remind everyone of the new MCLE technology requirement that is in place this year, talking about attorneys' duty to have a competency in the technology relative to practice. So by the steps you're taking here, you're getting your students ready when they become graduates to continue that competency into their practice. Are there any schools taking any sort of different strategy?
You know, we are at Laverne pretty much having the similar conversations that Dean Hunt and Dean Freiberg and the exploration. And as you pointed out, the challenge is it's just so accelerating that we can't keep up with by the time we get a sense of what we're looking at in the landscape. We've kind of defaulted to the conclusion that we need to find a dedicated AI research specialist who is just basically going to keep up with what I think is going to be moving at such a fast pace and be a subject matter specialist. So that's the route we decided to go. I think it's just going to get bigger and bigger and bigger, and with it, more and more responsibility of what this legal research, I don't want to call it a weapon, but certainly a tool that's going to be, and you know, especially the generative AI. I mean, it seems to me that its answers today and its predictions and its direction it might give today will be different with the very exact same request tomorrow, because it's too evolving. So I say all that to say that we are definitely in the middle of the conversation. And I appreciate the State Bar's acknowledgement that at this point, it's just moving so rapidly, it's hard to get a grasp of it.
And as part of getting ready to create that guidance, we'll be reaching out to all of the schools to get a sense of what you're doing now, what questions you have, what concerns you have, and if you have any policies or courses in place right now, so that we can bring that back to CSBARS for a more full discussion. Are there any other comments that you would want to make about the schools specifically before we turn it over to Cody to talk about AI in its relation to the Chapter 6 process and bar exam? Okay, we'll look for more to come, and I'd like to thank Dean Frickberg and also Dean Marshall for being contacts to help prepare a more specific discussion at a future CSBARS meeting. Okay, so let's turn it over to Cody.
Great, thank you, Natalie, and thank you to our members. I'm looking forward to working together on this guideline document. As Natalie mentioned at the top of the discussion, the board has directed the Office of Admissions to look at two areas related to artificial intelligence. One, obviously the discussion related to law schools, and the other, a review of the exam rules and policies and the intersection of artificial intelligence and those rules and policies. So I want to provide an update regarding the discussions to date. And let's, Teresa, go to the next slide if we can. So at the October 2024 Committee of Bar Examiners meeting, staff presented to the committee members an introduction to some of the principles of artificial intelligence, and along with that, kind of an initial assessment of the existing exam rules and whether or not they were sufficient. And I should be more specific when we're talking about our exam rules. What we're talking about are really, I guess, two buckets. We have our admissions rules. So we have our admissions rules as Title IV, Division I of the State Bar Rules, and we have a specific section called Chapter 6 that addresses conduct, exam conduct, what we call our Chapter 6 rules. And then there are also separately our just internal policies related to how the exam is administered. So at that October 2024 Committee of Bar Examiners meeting, staff shared their assessment that the rules as they existed at that time were sufficiently broad enough to address the existing risks of AI. It was also determined that the Chapter 6 decision matrix, which is a document that clearly communicates what the consequences are for certain rule violations, was sufficient as it existed to at least address what we can today predict are the risks of artificial intelligence. But since then, staff and members of the committee have been working on proposed revisions to the Chapter 6 rules and guidelines. So I wanted to just reiterate which rules, guidelines, and policies are currently under discussion and why they remain sufficient. So we have Rule 4.70, which is related to conduct and standards. And we have this first line, engaging in any other conduct that would provide an advantage to the applicant. I think we believe that that's sufficiently broad enough to include the types of advantages that an applicant would receive using a tool like an artificial intelligence tool. We have guideline 4.70 E4 related to evidence of suspected cheating. Traditionally in a bar exam setting, we would have a proctor in person monitoring applicants as they were responding to as they were responding to exam questions. Now in our hybrid model for February 2025, we also have those that are being recorded through a video proctored scenario. So again, I think we believe that the type of engagement with artificial intelligence is likely covered by this section related to evidence of suspected cheating. And then again, the Chapter 6 decision matrix describes the consequences for engaging in such suspected cheating. And again, our initial review and assessment was that the language as it exists today would fit the kinds of instances we expect could happen, the types of usage of artificial intelligence that we could expect. Let's move to the next slide if we can. Now, that doesn't mean there aren't opportunities in front of us. The committee was going to consider the proposed Chapter 6 rules at the January 31st meeting. That too will be revisited in March. So I think there's an opportunity to consider once more maybe some specificity regarding technology and artificial intelligence. In those rules, as I mentioned, they're relatively broad, which means that it's a big tent of the types of cheating that we could expect, and so that works today, but it may be worth spotlighting in a more explicit manner. We have, I mentioned the second bucket, our internal policies for exam administration. We have reviewed our instructions and our exam day policies documents that are being shared with applicants ahead of the February 2025 bar examination, and we've introduced some languages that more explicitly address the fact that using artificial intelligence tools for responding to exam materials or producing notes for your exam materials is an exam violation. We've also introduced some language that submitting exam content into an artificial intelligence tool is also an exam security violation. So we've tried to communicate more clearly with applicants where possible, and I think that work will be ongoing as we continue to refine our bar exam communications policies and other rules-related communications in this new era of the hybrid exam administration. We, I think, acknowledged at the Committee of Bar Examiners meeting in October that staff really recognize that this space is evolving, and that it is here to stay. So, I think we are more prepared to revisit our rules or policies if novel issues present themselves, again, particularly as we head towards our February exam in a remote setting. And then lastly, this is likely our big update since we last met and discussed artificial intelligence. But in October 2024, the Supreme Court issued an order to the State Bar to work towards reforming the bar exam in the distant future. This was in response to the Blue Ribbon Commission recommendations, and in that order, one of the directions given to the State Bar is to identify practice skills-based assessments and exploring the use of AI or other technologies really to perform such assessments. So an ongoing effort of ours will be to explore and research whether or not there are opportunities to use emerging technologies to perform assessments or to otherwise introduce technologies in the exam administration process. Of course, all of that is at the ground floor of research, and any information that we gather, I think, will be brought to the Committee of Bar Examiners in the future as part of its future exam efforts. And I think that's it, Teresa. Happy to take any questions.
We'll have Dean Hunt go first, and I have a couple follow-up as well.
Yes. As far as the exam goes, at least my understanding would be that when they log in to take the bar exam, they would be on a browser that locks down their computer.
Yeah.
And so that the use of AI would theoretically be impossible. I mean, I understand you want to address things in the rules, but from a practical standpoint, they don't really have access to any other software, internet access, or anything besides the exam, correct?
Correct. So you're referring to the Guardian browser, and so an applicant in the February exam will be taking their exam in that browser, and you're right, only whitelisted web pages, which there are essentially going to be none, would be accessible. So I think the risk is small right now. I think to some extent there's an opportunity to maybe just anticipate, not expect, but to at least address the risk of artificial intelligence as an emerging technology that might produce unexpected risks at this point. But you are right that there's really kind of from a practical standpoint, no way for a test taker to access these tools in this setting.
The only option would be the use of a second computer, whether it's a cell phone or a different computer. But again, the proctoring, if I know with our students, if we see a cell phone, you fail the test. And the AI proctoring software, of course, if you look away from the screen for too long, it flags you and then we review it. So all of that's there for a practical standpoint. Okay, I was just checking on that. That's all.
Yeah, and I should note just one other detail about the experience. Not only are they kind of locked out from accessing other web pages, the proctor can see both their video on the applicant and also the desktop, right? So there's also this extra layer of kind of recording and documentation as well.
Excellent. Great. Thank you.
I'd actually two questions, but a follow-up with Dean Hunt's. And again, you might not be able to go into any detail about it because of security concerns, but the concern I would definitely have would be the use of virtual machines. Is the Guardian browser being used inside a virtual machine, which does not know that it's inside another computer where they have access to whatever they should not have access to, like a AI program? I don't know if we've already done any testing or if that's an area that you can discuss.
Dean Frickberg, I'm not sure I know that kind of issue area enough to speak to it. So let me take it back. This might answer your question, but one of the other layers of documentation and security that the exam platform features is that it does know when other applications are running on someone's computer. So a proctor can both require that an applicant close any running applications before they proceed, and can also monitor if anything turns on, or what applications run during the exam. I'm not sure that addresses your question because I'm not entirely familiar. So let me try to get you some clear response, but I want to share that other layer of protection that the platform offers.
Okay. No, definitely. And it might be just they do a scan. I'm not sure, but that would be one of the areas I would be most concerned at is the use of a virtual machine. And then the virtual machine doesn't know it's a virtual machine. So when it does a scan, it does not see anything improper as it goes through. And nothing can ever be perfect, of course. Right? There's security is an illusion to all of us as we go through. I was just curious from Dean Hunt's comment as we go through
And
that.
I'll look into that. Thank you for raising that.
The two questions I had in this area, one, again, past is always prologue to me. And I remember when we went back to the October administration, which was the July, COVID administration, there was approximately 9,000. I think it was one of the largest administrations ever, as I was referencing earlier, a lot of out of state, out of country. And from my memory, it was approximately a third were flagged for Chapter 6 violations. About a third, so over 3,000. I know that's an entirely different system, different proctoring system. Do you think we might have a similar potential problem here based on the experimental versions and the mock versions that have already taken place? Have you seen that as different?
I think we've seen it is very different. So let me first address the difference in the system. So you're right, the pandemic era system relied on artificial intelligence, and so there was, I think, an overinterpretation of certain behavior that led to a lot of violation flags. This is a live remote proctored exam, so there are humans observing at all times. We saw in the experimental exam and also in the mock exam, because the mock exam for remote test takers was proctored. We saw how the remote proctors engaged with certain behavior, and I would say that just anecdotally, the types of incidents that were flagged were generally appropriate, and I don't think we have a mass issue with violations being flagged that were not appropriate. I can just say anecdotally again, the kinds of things we saw were someone trying to enter the exam, but they had another application open, so the proctor was able to help them close that. We get a record that an incident occurred, but that may not lead to a Chapter 6 violation, particularly if it was all resolved before the actual exam. So it has not produced kind of a volume issue for either staff, and nor do I think applicants are going to find that they're being flagged for issues unexpectedly.
Oh, very good. That was my hope, and
Yeah.
I think many out there will rest knowing that better from the dialogue right now.
When we began this process, that was like a kind of a core principle, was that we needed to find a live remote proctor situation, and that's why we have not considered a like AI video generated proctoring platform in some time.
Well, definitely. My second and last question in this area, and again, I also enjoy experiments, improving concepts whenever possible. I don't know if the bar has thought about, after the administration of this upcoming February bar, but before you break apart your grading committees, have you thought about having the different AI platforms answer the questions when there's no danger of contamination of it going to the public, to see how would DeepSeek or how would ChatGPT answer those questions as a blind study, giving them to graders to see would these artificial intelligence programs pass the bar, as many allege, but I have not seen in my experiments internally, at least with law school.
We have not considered that. I think that's an interesting idea. So again, let me take that back, and maybe there's an opportunity for us to use some of this kind of contemporaneous exam material for some testing. I will say there have been no piloting of AI tools yet, but we are aware of some kind of exam-related tools that, like perhaps an exam grading tool that would allow us to take historic information, exam information, and pilot it in a platform to see how it performs. So if through our future bar exam research, there comes a point where piloting and using previous exam material makes sense, it may be something we explore, but we have not yet done so. But I think the idea you just raised is interesting, and I'll take that back to staff and see if there's an opportunity there.
Thank you. Any other questions or comments from our committee members on this topic? Not hearing any. Thank you. Thank you as always.
Thank you.
I think that leaves us one more point for discussion within our business section. So this is 7.2, discussion of proposed 2025 schedule for tasks delegated to the Committee of Bar Examiners. And I'll turn over to Natalie Leonard.
Thank you. Thanks, Dean Frickberg. So I wanted to talk to everyone about the committee's planning process and their timing for looking at some different topics this year. Some of you may already be familiar with this process, or for others of you, it may be new. In some years, the plan has been created and adopted in December, but this year it was discussed in December, but it's going to come back in January. So it could change just a bit. So we can set some tentative timelines and topics now, but it can change. And also, once a work plan is adopted, if there's a circumstance that requires changes, the committee can modify it in that way. And because we're lucky enough to have a member here, I wonder if Paul Kramer would like to speak at all about that process.
Maybe after you make your presentation, but I don't have anything specific. Just to emphasize that it is very much a working document, and one of the things I've tried to get us to do is put it on every agenda, not so much to talk about it necessarily, but to remind the committee members, the CBE members, that is, what we are doing and what we are expecting to do in the future. And we're also trying to use it to track long range issues that we can't work on today. An example of that would be after changing the cut score for the first year exam, we need to give that a few years and see how well it continues to serve as an accurate predictor of success on the bar exam, because that's one of its functions. And obviously we can't do that because we've only changed the score maybe for this upcoming administration. I guess it was last year's, but those students who are just going into their second year won't even be taking the bar exam for another 3 years. But my point is, we want to put it on our list so we don't forget about it. And that's one of the functions of the work plan.
Thanks, Paul. Okay, so let's go to our slides. Okay, let's go to the next one. So I'm actually, you know what, Teresa, could we actually use the version that is in the folder, which is, I think, a little bit different than this one? Thanks. Or I can share my screen as well. Would that be better?
Sure. Yeah, let me see. I gotta stop sharing. Sorry.
No problem. Okay, give me a quick second and I'll go ahead and share my screen. Thanks. Okay, great. So each year, the committee looks at its work plan, planning it out for the full year. They also look at the work plan at each meeting and talk about what the status is. And you're welcome to watch this anytime, each time. So they began by talking about some of the accomplishments from the prior committee year, 2023 and 2024, many of which CSBARS was involved in and some of which are going on right now. So first of all, just looking at overall initiatives to improve outcomes in unaccredited law schools. And right now, you know that you've provided significant feedback over a number of meetings regarding the unaccredited law school rules, and those proposals will be considered by the CBE for adoption in one of the upcoming meetings. They also reviewed the law school profile report, which was discussed here, and the law school performance report. It's going to be on your work plan for this year to talk about the contents of those reports. They also evaluated the committee's role related to non-JD programs at law schools, which resulted in some statutory amendments that went into effect at the beginning of January, and we may be providing an interpretation of that as the year progresses. And the jointly accredited application has also launched for accredited law schools that are also accredited by an institutional accreditor. So in December, they talked about what had happened. They talked about what they would like to happen in the upcoming year. And there were a few open items that will be discussed in January. And I think they said, and Paul, I wonder if you would agree, that it seems that there are always more things that they would like to do than there are time or resources in a given year. So this is a combination of determining the things that they would like to see, as well as what they can accomplish in this year. And I think that that refers to what Paul was saying about making sure that the committee keeps track of future initiatives as well as longer term initiatives as part of this planning process and the prioritization process. So
Yes, we have to keep in mind that there are some perhaps some new structural limits on the bar. We haven't received a report, but the bar was asked to reduce its staffing count in the fee bill. And if you looked at the Board of Trustees agenda, I don't know what the outcome was, but they were asked to adopt a golden handshake program to encourage some staff members to retire. So they're throwing more staff at whatever problems we might have or projects isn't looking like a feasible option anymore. We have the continuing challenge that the fees that are charged don't necessarily provide or pay for the full cost of the admissions functions. So we are very much working on a shoestring, at least from it appears to me. These are my words. I don't want to pretend that staff is saying that, but that's my observation. So that's that, and frankly, that some of the items on our January agenda are being postponed was a function of the amount of time we have during the meeting and the need to address some issues that relate to the upcoming bar exam that cannot wait until a future time.
Thanks, Paul. Yeah, that's correct. One of the things that was scheduled to be introduced, as Cody mentioned earlier in the January, was an early version of proposed modified guidelines, and those will be introduced at a future meeting, and you'll see that on our chart very soon. CSBARS is a critical part of supporting the CBE's work plan in providing feedback on topics related to law school regulation. So what we wanted to do is to review the tentative CSBARS topic schedule pending CBE's continuing review of its own work plan in January. And while it does review the plan each month and changes can happen each month, the majority happen during this time period, the planning process in December, and in this case, perhaps January. We hope that this will help you to plan your workload, but also to provide additional notice to the public of the tentative timing for the discussion topics here at CSBARS. So as public members want to participate, they can prepare their calendars to do so if they'd like to participate live rather than reviewing the meeting recordings. So there are 4 more meetings left in the CSBARS committee year. A committee year here is very much like a school year on trend for this program. And the last meeting of the committee year takes place in August. So based on a review of the current work plan, we're suggesting the following. And it does mean a busy March, especially with the potential move of the guidelines. The first one being, thank you already, to Deans Frickberg and Marshall, some more detailed practical guidance for use of AI to create a preview that could be shared later with the Committee of Bar Examiners. We'll also bring back to you the law school performance report format to see if you have any suggestions about that document, additional measures, additional charts, additional data collection that should be used to inform that annual report that provides a snapshot to the Committee of Bar Examiners and the Board of Trustees about the performance of both CALS and unaccredited law schools. We'll also ask for suggestions related to the annual report and may be ready to discuss the guidelines with the recent change that might not take place until April. So you see that as the one item where we've placed on 2 different slots in the timelines. We also think that the practical guidance might take more than 1 meeting. So we're wanting to potentially schedule it for 2 meetings, both March and April, before the committee is ready to take it up in June. And that's when they plan to do that. We'd also like to collect from you some feedback regarding the Bar Retaker Support Group. You might remember this is a new initiative of the Lawyer Assistance Program. It was offered in conjunction with the July bar exam and then offered again in conjunction with this February bar exam, and it's actually just concluded. We received significant, we received very positive feedback about the first instance of the program, but we also received a lot of suggestions from both ABA schools as well as CALS and unaccredited schools, and LAP worked very quickly to make modifications based on that feedback. So we think it would be worthwhile to do that again. In the June meeting, we'd like to tell you about some changes to state bar demographic definitions that we've been using and that we're also piloting. And then by August, the law school performance report will be issued, and we'd like to share with you the findings of that report that is largely created by our Office of Research and Statistics. So first of all, I'd like to get a little feedback on this schedule. And then offline, what I'd like to do is send out something like what we talked about here to get a volunteer or 2 for each of the topics so that you can be a contact for staff to help us prepare the discussion for CSBARS so that it can be as rich as possible during the time that we have together. Are there any questions about this schedule, or is there any interest to move around any of the topics that are on here? I'm guessing that they're not surprising. It's probably the set of topics that you expected. And offline, what we'll do is we'll provide a list of these topics. You can let us know which ones you're interested in so that we can set these up, and then we can bring back to a future meeting who is the contact staff for each of these so that that is known to everyone, and then we can get busy on this work for the committee.
One question, Natalie. The annual report format, you're talking about the format of the document the schools use to report their demographic data, right?
Not just the demographic data, but the overall compliance report that is released that is due by the schools in November.
Okay, but it's what they give us, not what we produce from it.
Correct. So
Okay.
the annual report is what they provide to the state bar, and then the law school performance report is what the state bar provides back out to the public.
Okay, thanks.
Okay. All right. Well, thank you, everyone. We appreciate you being willing to try something with us, which is to be creating a work plan for CSBARS as well. We know you are busy. We know you've gone through a lot of different changes this year, and you're incorporating a lot of new things like AI, and we want to appreciate your participation and respect your time as well. Okay. Dean Frickberg, I do believe that we have completed the agenda.
In record time as well. Just to point out for everyone, I know I have a tendency sometimes to go long, but we always finish. The plane always lands, but sometimes a few minutes longer. So it's 2:11. So I give back to everyone their time to rest or to work on other projects, and we stand adjourned. Thank you.
Thank you, everyone. Take care.